Negligence 101, Class 3, Standard of Care. Transitioning from establishing a duty of care to the role of the standard of care. Once a court determines that a defendant owes the plaintiff a duty of reasonable care, the analysis does not immediately turn to the question of whether or not the defendant breached the duty of care. Instead, the inquiry shifts from whether the law imposes an obligation to act with reasonable care, that's to determine whether or not there is a duty, to what the obligation of that care is specifically. So the duty element answers this question: does a legal obligation to exercise reasonable care exist? If that is answered in the affirmative, we then have to look at the doctrinal bridge, which is the standard of care inquiry. The standard of care inquiry defines what that duty, what that legal obligation is. So what the standard of care does is it translates an abstract duty of care that is owed into concrete conduct or behavior. Makes sense? It identifies the applicable measure of reasonableness. For instance, is the measure of reasonableness that of a reasonable person? Is the measure of reasonableness that of a skilled or trained professional? Is the measure that should be expected in those circumstances that of a reasonable child? Once we've established the measure of the legal obligation that is due, we then go to element 2, which is breach. And the breach question specifically asks, did the defendant fall below the applicable standard? Get it? So it's a 1, 2, 3 punch. Element number 1, duty of care, is asking, is there a legal obligation owed to the plaintiff? Before I can get to element 2, which is, did the defendant fall below the standard, I have to establish the standard. And that is what the standard of care does. The standard of care is the legal measure of how a person must act or should act in order to satisfy the duty of reasonable care. The standard of care does not ask what the defendant believes or what the defendant thought was safe. Instead, the standard of care asks how a reasonably prudent person would have acted under the same or similar circumstances. The inquiry is objective. The inquiry is objective. So the reasonable person is the objective standard, right? Think about this. A person, in accordance with Restatement 3rd of Torts, is negligent, Section 3, if the person does not exercise reasonable care under all of the circumstances. Section 3 of the Restatement 3rd of Torts goes on to identify factors that must be considered in the determination of whether or not the person acted reasonably. See, it's an objective standard. It is not a subjective standard. It is not what does the defendant believe is reasonable? What does the defendant intend to be reasonable? What does the defendant think is reasonable? That is not the question. The question is, what would a reasonable person do under all of the attending circumstances? And the factors that are going to be considered pursuant Restatement 3rd of Torts, Section 3 is foreseeable likelihood that the defendant's conduct will cause harm, foreseeable severity of any harm that may be caused, and the burden of precautions to eliminate or reduce the risk of harm. Conduct is not negligent simply because it produces an injury. Conduct is negligent because it exposes others to unreasonable and foreseeable dangers that a reasonably prudent person would have taken steps to avoid. It is an objective standard. Okay, let's talk about the standards, because up to this point, the only standard that we've discussed is the reasonable person standard. So what should we expect from these standards? We can expect that the standard of care is objective. We can expect that the standard of care is contextual. We can expect that the standard of care is normative. Remembering, however, the standard of care is not a detailed code of conduct. And we can expect that the standard of care will perform an institutional function. Well, let's take a moment and look at each of these expectations individually. The standard of care is objective. What do we mean? The standard of care is an objective measure of conduct defined by how a reasonably prudent person would act under the circumstances. The standard of care evaluates conduct by reference to a reasonable person, okay? It does not depend on the defendant's subjective belief or good faith. Accordingly, a defendant's good faith or honest judgment does not preclude a finding of negligence liability. Liability may be imposed whenever the defendant's conduct falls below the level of care that the law requires of a reasonable person under those circumstances. This objective framework promotes consistency and fairness in negligence law by ensuring that liability turns on externally defined social norms and expectations of social responsibility. Makes sense? The standard is objective. The best case is a case from 1837, and it's a case from across the pond. It's Von v. Menlove. This is an example of objective standard of care. What is the issue in the Menlove case? Well, the issue is simple. The rule of law is, under the negligence doctrine, the legal question to be answered in the Menlove case is, does a defendant owe a duty of care to a neighboring landowner? Well, if that's as far as I go, well, maybe the defendant owes a duty of care. Maybe the defendant doesn't owe a duty of care. What are the contextual circumstances? The circumstances are when the defendant maintains a haystack in dangerous proximity to the neighbor's buildings, despite repeated warnings of the risk that the haystack will spontaneously combust. 3-point issue statement. Under the negligence doctrine, does a defendant owe a duty of care to a neighboring landowner when the defendant maintains a haystack in dangerous proximity to the neighbor's buildings, despite repeated warnings of the risk that the haystack may spontaneously combust? Well, what are the facts? Well, based upon the issue statement, if you haven't read this case, you probably understand that we have a defendant, that's the actor, and we have a neighbor. The defendant has his own property, the neighbor has his own property. More specifically, August 1, 1835, the neighbor is telling the defendant that the proximity of the defendant's haystack on the defendant's land is so dangerously close to the borderline between the two properties that if the defendant's haystack were to spontaneously combust, it would increase the risk of harm to the neighbor's property. Despite being told about the danger several times in the weeks prior to the spontaneous combustion, the defendant's position was he'd take a chance. He'd take a chance on what? He'd take a chance on whether or not the haystack would spontaneously combust. And if it did, whether or not that would cause harm to the neighbor's property. The defendant did create a chimney, but that didn't prevent the haystack from spontaneously combusting, which it did. When it spontaneously combusted, it ignited and burst into flames. The fire spread to the defendant's buildings on his property and the plaintiff's buildings on the plaintiff's property. 1837, the property was worth around close to 500 francs. That's the neighbor's property. And so the neighbor sued. Get it? Pretty simple. Really old. What happens? Well, we have a jury, and the judge instructed the jury that the question to be answered was whether the defendant acted with the care that a reasonably prudent person would have exercised under those circumstances. Answering that question, no, the defendant did not act as a reasonably prudent person would have been expected to act. The jury found for the plaintiff, right? Of course, the defendant appeals, seeking a new trial, and the basis for that new trial was that the jury should not have been instructed by the judge to hold the defendant to a reasonably prudent man standard. But instead, the jury should have been allowed to consider whether the defendant acted in good faith according to his own best judgment. The motion for new trial was dismissed, and the jury verdict stood. Why? Because your subjective belief or your subjective understanding about what risk is and what risk is not the measure. What's the measure? A reasonably prudent person. And the jury found that the defendant did not act in accordance with that expected level of care. What is the rule of law that comes out of Menlove that is still good law? A defendant is negligently liable for harm caused when his conduct creates a foreseeable and unreasonable risk of harm falls below the standard of care of a reasonably prudent person under the same or similar circumstances. This is what we mean when we say that the standard of care is based upon an objective standard. Got it? The holding in Minlove, the defendant had a duty of reasonable care due to the foreseeable risk of the harm. Got it? That is what we mean when we say that the standard of care is objective. Moving on to standard of care being contextual. What do we mean when we say that the standard of care is contextual? The standard of care is contextual because what counts as reasonable care depends on the specific circumstances in which the defendant is acting, right? The Restatement Third identifies the factors relevant to reasonable care. We just read them. Foreseeable likelihood that we will increase the risk of harm, foreseeable severity of that harm, and the burden of precautions to reduce or eliminate that risk, right? So what constitutes reasonable care in a quiet residential neighborhood may differ from what constitutes reasonable care in an industrial work site. The standard must adapt to the factual context of the circumstances without abandoning the normative core. So the standard of care is contextual. It adapts to the facts, right? The facts matter. In other words, reasonableness of the care is not fixed, right? It varies with the circumstances of the risk, which is all going to be fact dependent. Again, taking you back, Restatement, Third of Torts, Section 3. If you continue to read the second paragraph, it is going to explain to you that the reasonableness of the care varies depending upon the foreseeability of the harm, the severity of the potential harm, and the activity being undertaken, taking into consideration whether or not there were things that the defendant could have done to reduce, or even better, eliminate the risk. So what are some of the practical things that you're going to be looking for when you're looking at the contextual considerations? Look at the activity itself. Look at the location. We just said what may be reasonable care in a very quiet residential neighborhood may be very different in an industrial worksite. Is there any time pressure involved that needs to be taken into consideration? Are there any emergencies that need to be considered? In addition, what are the legally relevant characteristics of the defendant? We're going to get into that as we actually get into the 9 standards of care that we're going to review. But for instance, the legally relevant characteristic, are we talking about a defendant that's a child? That's legally relevant. Are we talking about a defendant that's professional? That's legally relevant. Are we talking about a physically disabled person as compared to a non-physically abled person, right? So standard of care, not fixed, varies on the factual, contextual realities. Moving on, the standard of care is normative. Normative. What do we mean by normative? To say that the standard of care is normative means that it does not merely describe how people actually behave. It prescribes how people should behave. The standard of care being normative means that it expresses society's expectations about how people should behave. right? So it's normative. It is a statement of social expectation. That's right. So while we call the standards of care a bridge between the establishment of a duty and a determination as to whether or not the duty has been breached, but the standard of care is really what breathes roja, what breathes life, right, into what we mean by duty of care. Now, please, 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 as you are trying to find tangible guideposts to guide you through this standard of care bridge between the establishment of a duty of care and the determination of the breach of the duty of care, be mindful. The standard of care is not a detailed code of conduct. And that makes sense because we just said that the standard of care was not fixed. We just said that it based upon the factual realities, it based upon the context. Well, standard of care is not a detailed code of conduct because it does not provide precise instructions for every situation. It is flexible. It is based on evaluative principles. It operates on a comparative benchmark. Okay. Understand, the reasonable person is not the most careful, most cautious person imaginable. The reasonable person is not perfect. The reasonable person standard serves as a comparative benchmark, not an idealized model of perfect behavior, but a comparative benchmark. Keep that in mind. We are comparing what the defendant actually did in those circumstances to what society would expect to have been done. Okay. Last characteristic, standard of care is institutional. The standard of care is institutional. What do we mean by that? When we say that the standard of care is institutional, we mean that the law assigns different components to different decision makers, right? Institutional, by assigning different components to different stakeholders, different decision makers, we preserve legal uniformity and we preserve democratic legitimacy, right? Specifically, what I'm saying is the courts get to define the standards. The jury gets to apply the facts to the standards. So we have two different, very diverse, oftentimes, groups of society being able to participate in what society deems to be an appropriate measure of law, right? The standard of care thus serves the bridge between the doctrine expected and the experience that is actually lived. So I'm going to go back just a couple of slides to this one that lists the characteristics so that we can just see that we've covered all five. The standard of care is objective. It is contextual. It is normative. It is not a detailed code of conduct. And it performs an institutional function. Now that we've talked about what the standard of care is, what the characteristics of the standard of care are, I think it's a great time for us to go ahead and jump into the principles of the standard of care. So I told you before that there's going to be 9. Let's take a look at the 9. The first standard of care is the general reasonable person. That makes sense because that's all we've really been talking about. This hypothetical, not perfect, but serving as a comparative model as to what society expects people should do, depending upon the circumstances, when it comes to risk. When it comes to risk, right? When it comes to risk. So the general reasonable person is the default standard. That's the measure. That's the default standard of care when we're speaking with the actions, the conduct, or the behavior of an adult. Standard of care 1, that is our general reasonable person standard. That's one of the 9 that we're going to discuss. The other 8 are considered modified standards of care. Okay. Although negligence doctrine begins with a reasonable person standard, experience shows that reasonableness cannot be meaningfully assessed without accounting for certain legal significant characteristics of the actor. And for that reason, the law recognizes a limited number of modified standards. And what you're going to see, with the exception of one of the 8, the standard is not being modified. The standard is always reasonable care. One of the 8, the standard is actually modified. The other 7 of the 8 modified standards modify the characteristics of the reasonable person. They don't modify the standard of reasonable care. Okay? Let's jump in. Modified standards of care are important. Let's go back one slide. Modified standards of care are important because they do not abandon objectivity and they do not create individualized, subjectified liability, but they preserve the reasonable person framework, right? Again, the standard of care is always reasonable. What changes is the characteristic of the comparator. The modified standards are important because one of the social expectations of adhering to standards of care is that the standard of care may serve as a deterrent, right? And a regulatory function, especially since the standards of care are expected societal expectations, right? The standards of care modify behavior. The standards of care identify what's socially accepted and what is not socially accepted. Well, if you know me, you know I like tables. So here's a table of the 9 principles. The first principle we've already identified to be the general reasonable person principle. We get that from Restatement 3rd of Torts 3. I did make the Restatement 2nd of Torts reference if anybody's using the Restatement 2nd of Torts. If you're in my class, we're using the Restatement 3rd of Torts. There's your reference highlighted in yellow. In other words, that is your rule of law. The table also lists the other 8 standards, one of which I said the standard actually changed, right? And that's going to be the child standard. But as we do with all things, we're going to slow it down a minute. We're going to take each of these one by one. Okay, so we're going to slow it down just a tad and take each of these one by one. So let's look at the general reasonable person standard. That's where we'll begin. This is for adults engaged in ordinary activities. I know you're probably saying, well, how are you defining adult and how are you defining ordinary activities? What did we say about the standards of care? We said they are contextual. So what does that mean? That means that it's not fixed, that it's going to vary. So let your hypotheticals guide you. Let the facts provide you with what it is you need to make the determination about the level of care that is being exercised by the defendant in your call of the question, right? If we're talking about standard one, which is general reasonable person standard, that is applied to adults in ordinary activities. This is the objective standard. It does not ask what the defendant thought was reasonable. It does not ask what the defendant thought in good faith. It does not ask what you think is reasonable, right? It asks what a hypothetical, reasonable person would have done under the same or similar circumstances. Do not substitute the defendant's intelligence, the defendant's judgment, or the defendant's temperament, or even the defendant's personal caution. Do not substitute that for the reasonable person. In addition, don't substitute your own. All right, we're talking about the reasonable person standard. What's the second standard? This is the first modified, but second standard on the table. Superior skill or knowledge standard. The superior skill or knowledge standard. When a defendant possesses special training or expertise, such as a physician, an engineer, a pilot, a professional driver, a lawyer, the law changes the characteristics of the reasonable person. Okay? The law always applies the reasonable person standard, with one exception, but it adjusts the attributes of the person. Got it? So the defendant is going to be held to the care standard of a reasonable person with that same special skill or with that same expertise. That pause was intentional. Wanted you to take a minute to just let it sink in. Okay. Moving to the third standard on the table, but the second modified standard. This is the child standard. It is here in this modified standard that the standard actually changes. When the defendant is a minor engaged in ordinary child activities, the standard becomes subjective in a very narrow way. And here's the very narrow way. The child is judged according to what a reasonable child of the same age, same intelligence, and same experience would be judged by. Minor child engaged in ordinary child activities, right, is going to be judged by a comparator that is a child that is of the same age as the defendant, the same intellectual level as the defendant, and the same experience of the defendant. Get it? The law recognizes developmental limitations, but it still imposes a duty of care that would be appropriate to that defendant child, to their level of maturity. That's the child standard. Now, we're not done with children. Children have two standards. That's the child standard in a ordinary child activity, and then we have the child standard in an adult activity. So there is an adult activity exception to the child standard of care. Okay. A child is ordinarily held to the standard of a reasonable child of similar age, intelligence, and experience, provided they are engaged in a ordinary child's activity. However, when a child engages in an activity that is normally reserved for adults and that is inherently dangerous, the child is then held to the standard of care of a reasonably prudent adult in the same or similar circumstance. What happened? The child now is going to be compared to that general reasonable person standard. Get it? Here's some things to consider when you're looking at the child who is engaged in an adult activity. Number one, the child is in fact a child. It's a minor. Number two, the activity is in fact an activity that is typically reserved for adults. Your mind can create hypotheticals that are rabbit holes to eternity. Don't allow your mind to do that, right? I can hear you thinking now, well, what about this? What about that? Well, what about this? What about that? In my community, such and such and such. What about this? What about that? Don't do that. Don't do that, right? You're not going to be tested on some Twilight Zone or Black Mirror experience of a hypothetical, right? So when we talk about activities that are typically reserved to adults, you're thinking of inherently dangerous activities in that they require an adult's level of skill, maturity, and responsibility, right? The activity itself requires a level of adult skill, adult responsibility, right? And adult maturity. For example, operating a motor vehicle. Can children drive? Sure, they can. Should they drive? No. If they are driving and cause harm, they're going to be held to an adult level, that the general person standard level, because they are engaged in an adult activity. What's another one? Driving a motorcycle. Well, my little cousin started motocross when he was 3 years old. That's amazing. That is absolutely spot on, right? If the 3-year-old is on a motocross bike and causes injury, the 3-year-old is going to be held to an adult standard of care. That's that general person standard. What's another one? Using heavy machinery. What's another one? Shooting rifles. What's another one? Flying aircraft, right? My 8-year-old nephew knows how to fly a plane. Great. Does that make sense? Right. So we have the child standard and we have the child standard that's based on an adult activity. So if we're trying to make a decision about what the standard of care should be, because we've already completed element 1, which says there was an establishment that there was a duty. We're now trying to find what the level of that duty is, right? If it's a child engaged in an adult activity, we're looking, number one, to make sure it was a minor. Number two, we're looking to make sure that we can explain that the activity is an adult activity because it requires adult maturity, adult skill, adult responsibility, right? We look at the risk of harm and we have to ensure that the risk of harm arises from the activity itself, right? The injury is the result of conduct directly connected to the activity, right? The activity must be the source of the risk. And then we have to take into consideration public safety. Because the activity poses serious risk to the public, courts usually require a single uniform standard of care for all participants, regardless of the age. So again, is it a public safety issue? Once the adult activity exception is applied to a child, the standard of care is that of a reasonably prudent person. That is our general standard of care. Get it? All right, let's move on to the next standard. The next standard is that of a defendant with a physical disability. This is the physical disability standard. If you're going through the table with me, let me just go back a couple of slides. We are right here, the physical disability standard. Remember, we're going through each one of these standards one by one. Each of the standards, I've highlighted for you in the right column what the restatement third section is for that particular standard. That way you can go and look at the particular rule of law for that standard and look to see what the elements or the considerations are. Going back to physical disability, when a defendant suffers from a physical disability, the defendant's conduct is evaluated according to what a reasonably prudent person would do under the same or similar circumstances with the same physical disability. Please understand, the standard is not eliminating the duty of reasonable care. The standard is modifying the content of the standard to reflect the defendant's physical condition. Get it? So the question that's being asked is, how would a reasonably prudent person with this disability have acted under the same or similar circumstances? Still, reasonable person. The modification is in the characteristic of the comparator, right? Got it? What are considerations? Well, there has to be the existence of a physical disability. How am I going to know that? It's going to be in your facts. The physical disability must be relevant to the risk creating conduct. The physical disability has to be connected to the risk creating conduct. We know that there's an objective comparison between the physically disabled reasonable person and the physically disabled defendant. We also have to consider whether or not the defendant had reasonable use of available precautions or aids, and whether or not they use those precautions or aids. Okay, again, right here, we are not determining breach. Right here, we are only determining what is the measure of care that will be applied to this situation. What is the measure of care that will be used to compare the conduct of the reasonable person to determine the breach? The measure is the standard. And the physical disability standard of care applies to a permanent physical disability as well as a temporary physical disability. You want more specifics about the physical disability standard, go to the table, look up the restatements. Got it? Excellent. Let's go to the mental disability. A defendant with a mental impairment is generally held to the ordinary reasonable person standard. So that's two of these modified standards that really aren't modified at all. Remember, the child who's engaged in adult activity is going to be compared to a reasonable person standard, and we know the reasonable person is an adult. A defendant with a mental impairment is going to be held to the reasonable person standard. Got it? All right. Moving on, the emergency doctrine standard. The emergency doctrine standard recognizes when a defendant is confronted with a sudden and unexpected peril requiring immediate action, the law does not evaluate the defendant's conduct by the same standard of care in ordinary situations. Why? Because it's not an ordinary situation. It is a situation of sudden and unexpected peril. So instead of the defendant's conduct being judged by what a reasonably prudent person would do in ordinary circumstances, the defendant's conduct, who is facing an emergency, is now going to be judged by what a reasonably prudent person would do in the same emergency situation. We're really not saying anything different, because what is the circumstance for the reasonable person? Well, it's whatever the circumstances are, right? So we've got a reasonable person, we've got the defendant. Is the defendant acting the way that we think the reasonable person should act under the same or similar circumstances? So with the emergency doctrine, it has to be the same or similar circumstance. So, right, it makes sense. The defendant's conduct is judged by reference to what a reasonably prudent person would do in the same emergency situation. Okay, what are factors to consider? There has to be a sudden and unexpected emergency. The sudden and unexpected emergency cannot be of the defendant's own making, right? So now there's got to be a sudden and unexpected emergency, but it can't be a sudden and unexpected emergency that was created by the defendant, right? And the defendant's conduct is evaluated according to what a reasonable person would do in that same emergency circumstance. We only have two more to go. Custom and industry practice as a standard of care. Custom and industry practice as a standard of care. This modified standard refers to the habitual or common methods of conduct used by members of a particular profession, members of a particular trade, or members of a particular community. Customs may be introduced as evidence of what may be reasonable. I emphasize something here. Customs may be introduced as evidence of what may be reasonable. However, custom and industry standard alone does not establish a legal standard. Let me slow down. Evidence of a custom or an industry practice may be considered in determining whether a defendant acted reasonably or not. But compliance with the custom or the standard does not necessarily establish due care, right? So while a modified standard for a child, and no, that's not a good example. While a modified standard for a person with special expertise will allow the court to determine the standard of care based upon a reasonable person in that expertise, it does not play the same with custom and industry. Just because it's the custom to do it this way doesn't automatically mean that I'm going to be looking for a reasonable person within the custom. Custom is nothing more than evidence of the possibility of a standard, right? So the custom and industry standard, modified standard of care, is not dispositive. And there's several logical reasons why. One reason that it's not dispositive as a standard of care is because the custom itself may be unreasonable, right? An entire industry may follow an unsafe practice. If so, adherence to the custom wouldn't excuse the negligence, right? What's another reason why it's not dispositive? Because a custom cannot displace or replace legal judgment, right? A custom is something to be considered. It's considered along with foreseeability of harm. It's considered along with severity of risk. It's considered along with burden of precaution, right? It's considered along with the availability of safety alternatives. But by itself, just because the shrimping industry has a custom does not make that the rule that is going to be used to judge whether or not a defendant has acted reasonably under those circumstances. And the last modified standard, so this is going to be standard number 9 in our table, but standard number 8 as far as the modified standard is the negligence per se standard. Pay close attention, please. Negligence per se can be used as a standard of care, and it can be used as evidence of breach of the standard. Negligence per se can be used as the standard of care, and it can be used as evidence of breach. Okay, what are we talking about right now? We are talking about the bridge to get to breach. So right now, we're focused on negligence per se as a standard of care. Under the doctrine of negligence per se, a statute or regulation may define the applicable standard of care when the plaintiff is within the class of persons that the statute or regulation was designed to protect, and the harm is the type of harm that the statute was intended to prevent. Under the doctrine of negligence per se, when we're looking at standards of care, a statute or regulation may define the applicable standard of care when the plaintiff is within the class of persons the statute was designed to protect, and the harm is the type of harm that the statute was intended to prevent. Why? Think about it. If the legislature enacts a statute, or if there's a recognized regulation that is designed to prevent a kind of harm, and designed to protect a particular group of people from that particular kind of harm, Why would we need to be concerned with what a reasonable person would do in those same circumstances? The legislature has spoken as to what the standard is. They've spoken by enacting a statute or regulation. And so if the legislature has spoken and said that this will be the standard of care because we are addressing this particular kind of harm and this particular group of people, then you don't need to second guess it or take the deliberation any further than that. That makes sense? All right. Negligence per se as a standard of care. When is a statute or regulation capable of being used as the measure by which we will compare the defendant when we get to breach? Well, the statute or regulation can be used as a standard of care when the plaintiff is within the class of persons that the statute or regulation was designed to protect, and the harm is the type of harm that the statute was intended to prevent. Think about that for a minute. Think about that for a minute. There's some really clear examples, right? But here's one. Let's say we have a city ordinance. All apartment buildings must install and maintain operational smoke detectors in every sleeping room. If you're living in an apartment and you have a bedroom, ordinance says gotta have a operational smoke detector. Yeah? Okay. A tenant is injured in a nighttime fire because no smoke detector was installed in her bedroom. Ooh. 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 Don't jump to that's a violation of the statute. That's what negligence per se looks like when we are looking at breach. Right now, all we're trying to do is find out what are we going to compare the defendant's behavior to? What standard of care? Well, let's continue. The tenant sues the landlord in negligence and argues that the ordinance applies the standard of care. See? So we're trying to say, well, what would a reasonably prudent landlord have done? Well, in that circumstance where the legislature or government officials have enacted either a statute or regulation, which an ordinance is, the legislature or state government or county government has determined what the measure is going to be, what measure is going to be used to compare what a defendant has done, right? The standard is whatever the law says. So the law says that the expectation is that if you're in an apartment, every sleeping room has an operational smoke detector. So what standard is the landlord going to be compared against? The reasonable person who has the operational smoke detector. Get it? The court analyzes the statute under the elements of negligence per se. In doing that, the court does two things. One, is the tenant in the class of people that the ordinance was written to protect? Yeah, tenant of an apartment, we want to make sure that there's a minimum level of safety afforded to people who rent apartments. So we're going to have this ordinance that says for Landlords, if you're going to rent your apartment, you got to have an operational smoke detector because we want to protect a class of people. The class of people, tenants. Is the type of harm, the kind of harm that the ordinance was intended to address? Right. Well, if I have a ordinance that says we need to have operational smoke detectors, what type of harm is the ordinance purporting to protect? Harm occurred in fires? Was the type of harm that this plaintiff was injured by a fire? Yeah. In her bedroom? Yeah. In her apartment? Okay. So we have the class of people that it was intended to protect and the type of harm it was intended to address. Get it? Perfect. Those are the 9 standards of care that we will be covering this semester. If you are asked about a duty of care, you are not done until you have, one, determined whether or not a duty is established. And if it is, naming the level of care that will be applied, which is naming the standard of care. You only have 9 of them. Okay. These standards, remember, operate within the framework of the Restatement Third of Torts. They do not create new duties. They're asking, what would a reasonable person have done under the same circumstances? The modified standards merely clarify the characteristics of the reasonable comparator. Yeah? So, again, if you're asked to determine if the defendant owed the plaintiff a duty of care, you're not done until you have established whether the duty was established at all. And if a duty of care is established, you must define the standard of care, which means you must define one of the 9 standards from the table. Here is a hypothetical that you can play with if you like to help you work through the duty of care and the standard of care. And there's the hypo. Paula operates a coffee kiosk inside a busy train station. The kiosk is open to the public, and Paula regularly serves commuters and travelers. Victor purchases a cup of coffee from Paula and walks a few steps away from the kiosk toward a nearby seating area. As he walks, Victor slips on a wet floor and falls. Paula sees Victor fall and observes that he is struggling to stand and appears disoriented. Despite this, Paula takes no action to assist him or to summon help and continues serving other customers. Several minutes later, Victor collapses and suffers serious injuries. Here's the question. Victor sues Paula. Does Paula owe Victor a duty of care? Right, here we go. There's that duty of care question. And if Paula does owe Victor a duty of care, what is the applicable standard of care? So think about video 2 and think about this video, Negligence 101, Class 3, video 3. Negligence 101, Class 2 was establishing the duty of care. Negligence 101, Class 3, this one is identifying the standard of care. You take both of those lessons to establish whether or not Paula owed Victor a duty of care, and if so, name that duty. It's been fun. Negligence 101, Class 4 will address breach of duty. Negligence 101, Class 4 will address breach of duty. I look forward to seeing you then.